here, I cordially welcome our beloved Secretary Saraswati Kannayan ma'am, Joint Secretary Priya Satish Prabhu ma'am for their wonderful presence for this occasion. Along with them, I welcome our beloved Karan, who is a backbone. So along with this, a warm welcome go to our HOD, Dr. K. Samuel, for his all-time support. A warm, privileged welcome to our chief guest of this function, Head and HR Administration, Indian Additives Limited, Chennai, who accepted admiration graciously amidst his busy schedule. Welcome, sir.
Thank you, madam. Thank you.
I welcome my fellow colleagues who were the helping centers behind this program. Last but not the least, I welcome all participants for this wonderful session. Thank you. Now I request our HOD to share a few words. Sir?
Yes, ma'am.
Yeah.
So good afternoon to one and all present here for this webinar on industrial law, new insights. Before going into the topic, it is a good coincidence that we, the chief guest of today's program, and we have met only in online, right? It's all only online. We are all become online friends actually, right? So in one of the conferences, he came, one of our program, which we organized, he came there. We had a good interaction in the program itself. And then sir volunteered to be with us, and he took one session in the last year. And again, he will be into all these HR areas, right?
Yes.
He will be analyzing. Yes, sir?
Yeah, please, sir.
Yeah. So that is how we are in touch with each other. So it's a good academic partnership that we have. He's in Chennai, we are in Coimbatore, and maybe without this online option, I think this relationship would not have been possible. So we hope that we take this for the benefit of our students and our HR community overall. So I thank him for being with us, and many more things that we can do beside together, right? So with that point of view, maybe we are going into this industrial law and new insights, right? So here we have three important codes that we are going to discuss, right? That is what sir will be talking about. Maybe the occupational safety, health and working condition code, the industrial relations code, and the code on social security. So all these things are a very, very broad area. And how do India fare up in this in a big way? It's a big question mark again. Because India is struggling to move from left to right? So that is the struggle that we have. So we can't go completely left, we can't go completely right. But still, we are moving towards the right. We don't know how far all these things can be accommodated, right? On social security, on all these things. And we also have our new Union Minister for Labour, Bhupendra Yadav, who has joined recently in July 8th. Now only has joined. And we had another minister who was there who brought this code. And this code is not yet implemented. Actually, they want to implement it in the April 2021. But till now, it is not being notified. So therefore, people are all waiting for the notification from the central government. So what will happen, how we are going to make it, how we are going to make it very easy for people, right? Because our labor laws are very strong, many industries are not ready to come into our market. So that's why when you go and see the industry, if you go to the industry, they will not give you direct employment. Many organizations will not give you direct employment. You will be put under contract. Many places, if you can see, even big companies take people by contract. So why all these things are happening is because our laws are very cumbersome. If people go into the legal angle, then it's a very tiring job for us to solve it. So whether we should see our business or this courts and legal aspects, it's all big question mark, right? So still now only we are trying to improve it. So let us see what will happen in the future and how this labor code is going to transform our businesses in India. We just have to see. So in order to get some good highlight from our guest speaker today, so we have organized this program. So I hope all of us benefit from this program and try to understand at least what is this labor code is all about. So with this brief introduction, I hand over the session to introduction of the chief guest will be there, and afterwards we hand over the session to our guest speaker. Thank you, sir.
Thank you, sir.
Sridhar? Yes, you can start.
Good afternoon to one and all present here. Myself, Sridharan. I take this opportunity to welcome today our chief guest, Mr. Chidambaram. I welcome you, sir, on behalf of Hindustan Business School.
Thank you.
Sir hold a master degree in personal management and industrial relations from St. Joseph College in Tiruchi and secure academic toppers. And successfully complete executive development program in human resource management from XLRI in Jamshedpur. Sir has overall experience 19 years in entire gamut of HR and IR function across diversified sectors such as chemical, electronic, textiles, contraceptive, and the service industry. Now currently work head of the HR and administration at Indian Additives Limited in Chennai. This is a joint venture between Chevron from USA. Sir certified compensation and benefit manager and certified HR analyst and merit professional from Carlton Advanced Management Institute and board has secured high distinction. And certified external member of post committee from National Institute of Personnel Management. Sir member of Society for Human Resource Management in USA and then life member of National Human Resource Development Network, National Institute of Personnel Management and Indian Society for Training and Development. And Sir avid reader of HR management and general management, psychology and labor law books. Sir delivered guest lecture on various subjects to eminent education institutions and attend external of Viva examiner to educational institutions. So Sir is passionate about teaching and sharing the knowledge, and leisure time activity include reading, playing badminton and table tennis. That's all. Also, once again, welcome you, sir, for this webinar.
Thank you, Sridhar. Can I start, madam?
Yes, sir. Yes, sir.
Screen is visible?
Yeah, it's visible, sir.
Okay. First of all, I thank the Hindustan College of Engineering and Technology for inviting me to share my knowledge on the new proposed labor codes. So basically, it's a 90 minutes session. So how I have actually framed this is we'll be handling the broad overview of the codes. Actually, it is a two-day program. Because there are 4 codes and around 44 laws have been merged into these 4 codes. It's a two-day full-day program. So whatever justice can be done to it in 60 minutes or so, I'll try my level best. But having said that, as how I have framed this is, we'll just have a broad overview of the theoretical part. Then we'll move. Then we'll have an interactive session. I would like to have this as an interactive session rather than a monologue, because then only if we collaborate, only it should not be a one-way dialogue. Otherwise, it would be boring, especially in a virtual environment. So I request you. I'll be asking then and there. I'll be requesting you to interact so that we can have the session very lively. So after the 60 minutes of delivery, we'll have an interactive session, maybe for 10 minutes. 10 minutes you can ask any questions related to labor laws, either existing or the proposed one. Then we can have a quiz. I have also created a quiz so that you can participate. So it's nothing but I have incorporated integrated gamification into the process. So through Kahoot, there is a app called Kahoot. If you have your mobile phones, you can this thing type that. I'll let you know when we go further. So basically, the broad content is, if you see, let us.
Sir, we can use the chat box, sir. Chat
Yeah.
box, we can use it. That is possible.
Yeah,
And
sure.
you can make your screen full screen, sir.
Oh, it's not full
So that,
screen.
it's yeah. And if you can make it full screen.
I'm clear, no? It's audible, no?
It's audible, sir. Audible, sir. Audible, sir.
Okay.
Hello.
Yeah. Hello. Actually, it's showing full screen. You are not getting full screen?
No,
we
sir,
are
we are not
getting
getting.
Okay. 1 minute. Just a minute.
You can come to the bottom right side, sir. There is a cup symbol near this size. Bottom right side, yeah. No, sir. There is a bottom right, yeah. Nearby, yeah. Left, sir. No, sir. No, sir. Left side. Next button. Yeah. That. Next button. Yeah.
Reading view, slideshow, slides order, normal. Just a minute, sir.
No, so the left side slide should be going off. That's the next. That one, sir.
It's clear now?
No, sir. Now we are seeing all the slides.
Oh, I see. 1 minute, sir. Now?
Now normally we are seeing, sir. Like last one we are seeing.
Yeah, full screen is not coming?
Full screen is not visible.
Coming.
Okay. I don't know what is the slide.
Okay, sir. No issue, sir. You can continue.
Yeah. Somewhere some issue. Okay. Yeah, I'll continue because we are running out of time.
Sir, try with F5, sir.
F5. Somewhere some problem, madam.
Yes, sir.
Yeah.
Okay, sir. No issues. We can continue, sir. That will be fine.
Yeah. So basically, we'll just start with the types of legal systems. We'll see, because one has to understand the legal systems, global legal systems which are available, which it's common throughout the universe. Then we'll see what is there in the Indian Constitution and what are the articles broadly, and what are the proposed labor codes, and what are the complicities. Why the proposed labor codes actually? What is the need for this proposed labor codes, and what are the complicities basically? Then we will move on to the benefits of these labor codes. Then basically there are 4 codes as Sir was enumerating during his introduction talk. So one is the code on wages, which was, as Sir rightly said, it's not been notified, but it's been passed in the Lok Sabha and Raj Sabha. It's been cleared by the Parliament and awaiting the respective state governments for the state governments to draft the rules. Okay, any act will have to be passed either by the legislature, that is either by the Parliament or the Assembly, State Assembly. And the rules has to be drafted by the concerned ministry. So it's waiting for that. Obviously, obviously out of 30 or 32 states, in the country. Some 5 or 6 states have already drafted the rules. Other states have to draft, so it's waiting for that. That's why it's not been notified. So one is the code on wages, second one is the industrial relations code, and third one is the occupational health safety code, and the fourth one is the social security code. The code on wages was published in 2019. The other 3 codes were published in 2020. Right. These are the 4 codes. So we'll not be having time to see all the codes, but I'll be highlighting the major changes, especially in the industrial relations code. Why I selected the industrial relations code as compared to the other codes, it doesn't mean that the other codes are not important. Other codes are also important, but the industrial relations is something which each and every budding HR professional has to know. That is why I have selected that. So we will discuss the major changes in the IR code, and the rest of the code just will be seeing the gist of it. Then we'll be moving on to the concerns of the labor code as such. What are the concerns? Obviously, there are benefits. There are also concerns. Right. Let me move. So the types of legal systems I said. So, sir, can it be? It can be in both. No, sir. It should be only in English, or it can be in both, or how is it, sir?
It can be both, sir.
Okay.
But preferably English will be, because people are from Kerala. A few people are there.
Okay, fine. Yeah, I'm okay. I'm very comfortable. Yeah. Okay, it's okay for me. Yeah.
Slide is not changing, sir. Next slide is not coming.
Not changing.
Yeah. And now it's okay, sir.
What about now?
Types of legal system.
Yeah, types of legal system. So basically, if you see any legal system, one should understand how the legal system has evolved. Can anybody say from the audience? Come on, quick, because we are having only another 55 minutes, another 65 minutes. Quickly, anybody can tell how in any country for that matter, how the legal system is derived, how the legal system is actually framed, on what basis, how do we evolve with the legal system? It's a common question. It's a general knowledge question. Actually, it has nothing to do with the legal. Can anybody tell quickly 1 or 2 answers, please, so that we can have it as an interactive session? From the audience, please, just you can unmute and tell. Even if it is wrong, it doesn't matter. Even I do not know 100%. Nobody knows 100% for that matter. Come on, quick. Yeah, I have seen at least more than 70 participants. Anybody, come on, unmute yourself and tell. At least say hello, ma. Come on. So
legal systems are used to safeguard the rights and basic benefits of a common person.
Correct, you are right. But my question is, on what basis each country frames its legal systems? What is the basis, on what grounds? How it derives this legal system? How the legal system evolves actually? On what basis? You are right. You are perfectly right. That is the objective of it. Any other person? Please. Nobody is going to eat you. Please. Even if it is wrong, okay. Somebody answered now. It was actually it was not relevant to the point, but he made a point. He had to make a point. It's okay. I also learned from you. Yeah. Please. Quickly, otherwise I will not be able to move. At least one voice. I'm not going to take anything from you. Come on. It's a very simple answer. It's a very simple thing actually. At the end of it, you will feel, oh, even I thought this is it. Can you tell? Come on, fast, quick. Let us move at the slide. I will not be moving.
Sir, in chat there is an answer coming, sir.
What is it, madam? Can you read, madam? Can you help me?
Rules and regulations are very strictly followed. Commercial, civil.
Okay. So, okay, let me tell. On what basis is basically how the legal system is based upon is basically it is based on our beliefs, based on a country's beliefs, values, and culture. Okay, each country has got a unique culture. In China, if you see, union is the norm in China, right? In US, whereas it is seen as a union is seen as a threat to the business, is seen as a competitive disadvantage in US. In certain countries, unions are the norms. In certain countries, unions are seen as a competitive threat to the competitive disadvantage. So, having said that, any legal system, it's basically how it is developed is based on the culture, based on the values, based on the cultural values and beliefs, based on our customs. So all these are only written in any legal system for that matter. Okay. So I'll move on to the next slide. Slide is changing, madam.
Yes, sir. Types of legal system. I think next slide haven't changed, sir.
Yeah. Legal system, if you see, Guneshwari, madam, if somebody gives an answer on the chat, I request you to help me, madam. Yeah.
Sir, the slide.
Slide is not moving.
The slide is types of legal system. Is that you're following, sir? Yeah. Now it has changed, sir.
Changed? Okay.
Changed.
Okay. So if you see, there are, as I said, it's a set of core beliefs about what constitutes right and wrong. What is right in one country may not be right in another country. Am I right? Am I making sense? What is right in our country may not be right in the Western culture. It will be looked upon as a different thing. Okay. So what we need to do is, before going and living in another country or doing business in another country, or going to work in another country, going for a job in another country, we should understand the culture of that particular country. What is the value system of that particular country? What are the core beliefs of that particular country, etc. We should understand. So that will help us to comply with the law, and also what are the requirements that are given in the law. So one will get a basic understanding. So it's basically culture, cultural beliefs and values. Any legal system is written based on the cultural beliefs and values. That is what I'm trying to say. Okay, there are three types of major legal systems in the globe. Universally, these three systems are there, irrespective of the culture. One is the civil law, second one is common law, third one is religious law. Civil law is very simple. It is written, nothing but it is a written code. Whatever is written is implemented. Each action, each decision, each judgment is pronounced based on the whatever is mentioned in the law, whatever is mentioned in the regulation. So it is a written code approved by the legislative body. Based on that, they pronounce the judgment. That is civil law. Okay. If you see, it is the most prevalent law in the globe. Civil law, the type of law, is the most prevailing system in the universe. Second one is common law. This is where our labor laws is bucketed under. So, under common law, if you see, the decisions are based on a legal precedence. If a judge is going to pronounce a decision, so he will refer to the old case laws. What the Allahabad High Court has said, what the Madras High Court has said, what the Thiruvananthapuram High Court has said, etc. So it will refer to those case laws and it will pronounce a decision. What I'm trying to say is, common law will be dynamic. So one judgment will be given at one point of time based on a particular situation. Whereas down the line, after 3 or 5 years, if you see, a similar case would have come up in the labor court, or for that matter in the High Court or in the Supreme Court. A different judgment would have been given. So again, what I'm trying to say is, the common law, one important point which you need to keep in mind is interpretation of law. is more significant than the law itself. How you interpret the law. Okay, so that is more important. Whereas in civil law, it is completely written codes, everything, whatever is there, you'll have to do. Whereas in common law, it is purely judge-made law. So, as I said, each case is considered on how judicial decisions have been made already. Already, whatever is the judgment made for for reinstatement of a workman for a particular misconduct. So the judge will refer to that and see if there is a theft of a particular value. What is the judgment pronounced? So he'll refer to that. So it's mostly common in UK. So whichever country has a connection to UK, whichever country, in other words, British has ruled, this common law is prevalent. So similarly, it is prevalent in India from the British era. All these labor laws were formulated by Britishers. Okay, all these labor laws, right from your Factories Act to your Sexual Harassment. Maybe Sexual Harassment Act is a new one. Right from your Factories Act, Industrial Disputes Act, everything was formulated by the British rulers who overruled India. Okay, so then moving on to the, I'm with you now, madam.
Yes, sir.
So moving on to the religious law, it's very evident from the name itself. It is self-explanatory. So it's based on certain beliefs and conventions. It's a mixture of 1 and 2, combination of 1 and 2, civil and common law, written codes and interpretations, based on religious scholars. So major religions have their own laws. Okay. For example, the Muslims have Sharia, Christians have canon. So similarly, Hindus have the Hindu Religious Act. So each religion has a law based on their beliefs and conventions. So these are the broad classifications of law. So one should understand this. So we are going to discuss mostly about common law. So because labor falls under that. Okay. So I'll move on to the next. So the next one is, see, what I want to discuss here is basically, if you see about the Indian constitution system, the Indian constitution is the largest constitution in the world. Largest constitution, I mean, it has around roughly, I may not be accurate. Earlier it was 395. I think now it has been increased to 448 articles. The Indian constitution now has totally 448 articles. Okay, 448 articles and 22 chapters and 12 schedules. So in that, if you see labor, which we are going to discuss now, here labor means employee, worker, which I'll be using it interchangeably, the terminologies will be used interchangeably. So here labor or employee, I'll use it interchangeably. So here labor means it comes under the concurrent list. What is concurrent list? Can anyone tell? Come on quickly, guys. Quickly, can you tell what is concurrent list or concurrent list? Come on quickly. Have your say. Come on quickly. Very simple, yeah. Why labor comes under concurrent list in the Indian Constitution? Something is there in the chat box, madam?
No, sir.
இருந்தா கொஞ்சம் சொல்லிடுங்க chat box.
Yes, sir. இருந்தா நான் சொல்லிடுறேன், sir.
Yeah, let us not. Yeah, why it's in the concurrent list is, come on, you students will have to tell something. Otherwise, I'm telling you, there is a big competition here in the job market. You will have to be interactive. Even if it is wrong, it doesn't matter. You will learn more from the wrong than from the right. We cannot pass in the first attempt. Okay, that is the way I believe. Yeah. Okay, why labor is in the concurrent list is, labor, the central government has also the powers, the state government also has the powers to enact legislation. That is why it is coming under the concurrent list. It's nothing but both the central has powers and the state has powers. So that is why we call this as a concurrent list. Okay, both the central government has also powers with respect to labor. State government has got powers with respect to enact a particular act or legislation. So that is why it comes under the concurrent list in our Indian Constitution. So next slide is changing, madam.
Yes, sir. Changing, sir.
Yeah, it's visible or very tiny. Should I enlarge it?
If you enlarge it, will be good, sir.
Now,
You can come down, sir, because the upper part is getting a bit. Okay. Okay, sir. Okay. No, sir, the upper part is going up. It is getting
yeah,
hidden.
yeah, I'll see to it. 1 minute. Now it's okay.
Now it's okay, sir.
You're able to see that, no? First line.
Yes, sir. Central Act plus central rules, no, it is. Right, sir?
Thank you, madam. At least you are speaking.
Uh-huh.
Central Act plus central rules plus state rules. Okay, this is what I was actually explaining. Any labor law, please understand, this is a very simple, basic concept which one should understand. Very, very fundamental, elementary concept one should understand. Any labor law can be framed by, any labor law can be classified into these categories. Either the act may be a central act, the act will be a central act, or a central rules or state rules. Example is Payment of Wages Act. I have put it in the brackets. Minimum Wages Act. So the act is a central act. Central government can frame the rules. State government can also frame the rules. That is one classification. Second classification is there are certain acts where it is a completely it's a central act and only central rules are there. Only central rules are there. Okay, there are no state rules. So we will have to follow the central act and the central rules. And the third classification is central act and common rules. Okay, central act and common rules. It's visible now, madam?
Yes, sir. It's visible, sir.
So central third classification is the pointer is visible now.
Yeah.
Central act and common rules. So what I'm trying to say is this is the third classification. Act will be a central act. Rules will be common for both state and central. Whereas in the first classification, if you see, as far as the minimum wages or payment of wages is concerned, payment of wages is a central act. There is a central rule. Again, there is a separate rule for Tamil Nadu. Factories which are based out of Tamil Nadu should follow only the Tamil Nadu state rule. Factories which are based out of Kerala which should follow only the Kerala state rule. So the difference between act and state, can you tell anybody? Only if you understand that, you will understand this. What is the difference between act and rule? Come on, yeah, please.
Come on, guys. State and central.
No. The difference between, I would like to hear from the students, the difference between act and rules.
Act and
Not
rules.
central state, act and rules. What is meant? What is act? What is rules? And just simple. It's very simple. Can you tell, please? Anybody of any one of you? Okay, act is actually what we have to do. Okay, what we have to do. Rules is how we have to do. Act is what we have to do. Rules is how we have to do. In other words, act can be enacted only by a legislature, either by parliament or assembly, either by parliament or state assembly. Whereas rules will be framed by the concerned ministry. In case of labor laws, by the labor ministry. Related to women and child ministry. So rules, act will generally be brief. Rules will be very comprehensive. It gives you the explanation to the act. In act, you will not have the entire explanation. So one should be aware of both. If you know the act alone, you cannot implement. So you should know the rule also. Okay. So the fourth one is state act plus state rules. There are some acts which are exclusively enacted by the state government. For example, the Tamil Nadu Industrial Establishment National and Festival Holidays Act. As per the Tamil Nadu Industrial Establishment National and Festival Holiday Act, any industry operating in Tamil Nadu is supposed to give 4 days of national holiday and 5 days of festival holiday. Okay, that is compulsory in Tamil Nadu. If you see in Karnataka, it will be different. So this is an exclusive act developed by, enacted by Tamil Nadu. And another act is Tamil Nadu Industrial Establishment Conferment of Permanent Status Act. That is another act. If any workman who has completed 480 days in 2 years should be made permanent. So something like that. These are acts which are specific to Tamil Nadu, which cannot be applied elsewhere. So overall, if you see, there are around 40 central acts in the labor domain. I am speaking, okay, in the employee domain, there are 40 central acts and over 100 state acts. So that you keep in mind, okay. These are some of the important things which you should keep in mind. So I'll move on to the next. So now we are coming to the subject. Just I have given you a brief overview about what are the different types of legal systems. Labor comes under the concurrent list. About the Indian Constitution, which is the largest constitution in the world in terms of number of words, largest constitution in the world. So I have given a brief overview about the how the laws are classified. Then now we'll move on to the proposed labor codes. Okay. So the slide is okay, madam. Hello.
Yes, sir. Yes,
Okay,
sir.
sir. Yes, sir.
Yeah. So what I'm trying to say here is, see, as even sir was enumerating during the beginning of this session. So these are the 4 labor codes which have already been published by the, if you go to, it's there in the public domain by the parliament, by both the houses of the parliament. So any act requires a president consent. So it's been cleared by the president. Only it's with the states to implement it. But having said that, the government will not endlessly wait. As sir said, during April itself it should have come. Yes, during April itself it should have come. Now, because anything which has to be implemented needs a buy-in from the employer, that is the industry body, from the trade union, and from the public. So it's lying there actually with the states. So these are the 4 codes. The code on wages, it subsumes, means it merges the existing 3 acts: the Payment of Wages Act, the Minimum Wages Act, and one more act. 3 acts it merges. In the Industrial Relations Code, it merges 3 codes: the Industrial Employment 3 acts: Industrial Employment Standing Orders Act, Industrial Disputes Act, and the Trade Union Act. The Occupational Safety, Health and Working Conditions Code 2020. So it merges 13 acts, starting from Factories Act, Contract Labor Act, Mines Act. Code on Social Security, it merges 9 acts: your Provident Fund Act, your ESA Act, your Bonus Act, Gratuity Act, etc. Okay. So the next one is, we will see. The next one is, so why these complicities? So one should understand. So India is the second in terms of population and 7th in terms of area in the globe. So there's complete diversity everywhere. Each state has got its own culture. Even within each state, if you see in Tamil Nadu, you should understand this. Even though you know, just I'm only recapping. The type of Tamil which is spoken in Coimbatore is different. The type of Tamil which is spoken in Tirunelveli is different. The type of Tamil which is spoken in Chennai is different. So there's a complete diversity. So our culture is one of the best cultures in the world. There's complete diversity. So that is why these complicities, basically. So this I have already explained. Concurrent list, judgments I have explained. This is unity in diversity. Whether it is possible to bring unity in diversity, it's difficult. It's really difficult. So the new labor code is aiming for that, to bring unity in diversity. So why I have put these 2 bullets in red is, let me actually highlight this. It's very important for you. I have put it in the red. Can anybody read it at least from the students?
Short title, extent and commencement, and definition.
Yeah, these two are important. Why I am saying is, any act, if you see that 40 central acts I mentioned on my previous slide, 40 types of 40 central acts are there, more than 100 state acts are there, I told. So any act if you take, or any bare act, any book if you buy, this short, one should understand the short title, extent and commencement. Then the definition. Without that, you will not be able to deep dive into the particular enactment, because a worker is defined differently under the ID Act, differently under the Factories Act, differently under the Wages Act. Similarly, wages, it's having n number of definitions, multiple number of definitions in different acts. So basically, the objective of the new labor code, what they have done is they have only, as I told it, as they have only merged everything. They have only copied and pasted whatever was there in the BAR Act earlier, erstwhile acts, maybe the current act itself, since it's not been notified. The current act, they have only copied and pasted, nothing that. And certain, yes, they have made some changes, which I will highlight. Certain changes have been done which benefits the employer, and certain which benefits the employees. Certain things benefits the employer corporate. Certain things have been changed for the benefit of the employees. Certain things are pro-employer, certain things are pro-employee. Okay. So these two things you must clearly understand, because certain acts do not apply to the state of Jammu and Kashmir. They have their own regulations. Certain acts do not apply to the, for example, to Goa. So you have to see that whether it applies or not. What is the definition of industry? Okay, in the industry, whether this is covered under industry. First, you should know what is the industry, whether the worker is coming under the particular industry. Then only you should see whether it falls under the definition of industrial dispute. So one should clearly understand that this extent means the scope, applicability, application of the act. So without knowing that, you can't get into it. Generally, it will be section 1 in all acts. If you see, at least 99%, I would say, maybe except for PF Act. Even PF, I think paragraphs are there. Generally, section 1, if you see, it will be short title, extent and commencement. Section 2 would be definitions. And there will be at least 20 to 30 definitions in each act. So one should be thorough with the scope and definition. Then only you can delve into other areas. So as I said, there is complexity in the term wages because different ceiling. In ESI, if you see, the ceiling is 21K. In PF, if you see, the ceiling is 15K. In the Industrial Disputes Act, the current ceiling is 10,000. There is something new ceiling is something is there. Again, under the bonus, there are two different ceilings. I think one is 10,000, other one is 21,000. Two ceilings are there in the bonus act. So different ceilings under different act, whether an employee will come under the bonus act, whether he will be covered under the pension act, whether he will be covered under the ESI act, whether he will be covered under the payment of wages act. So a lot of confusions. I wouldn't say confusions. So a lot of complexities. So one has to be thorough. So similarly, registration, you will have to make a registration, take a license under the Factories Act, you will have to take a license under the contract. If you engage contract labor, you will have to register your establishment under the Contract Labor Act. So similarly, there are so many, if you want to start a factory, at least there are 20 licensing requirements under various labor laws. So they are all proposing it to make it as one unified licensing requirement. So they call it as ease of doing business. Okay, there is an index called ease of doing business. The objective is to improve the ease of doing business. As far as India is concerned, India, I think, ranks in the bottom quartile. Then moving on to, yes, different minimum wages for different states and industry. If you have an auto industry in Tamil Nadu, the wage is different. If you have an auto industry in Kerala, the wage is different. Yeah, whether it is possible to avoid the complexity, we'll have to wait and see. Will it ever be simplified? Now only we are addressing That hopefully the government is addressing that. So moving on to the next slide. So benefits of labor codes we'll discuss. So as I said, basically it's to consolidate and simplify the complex laws. I really do not know whether that has happened because it is a simple copy and paste. As I said, yes, certain changes have been done. We'll see that. So the multiplicity of definition, yes, there is only now one definition for wage. There are no numerous definitions for wages. Now there is only one definition for wages. They have come with a single definition of wages. That is one good thing which has happened. Then, as I told, single licensing mechanism, easier dispute resolution, ease of doing business we have discussed. So other benefits, if you see for the employees, there is something which is introduced. FTE is nothing but fixed term employment. Okay. This is important. Something which is new has come. Fixed term employment. They have introduced.
Sir, I think if you are changing the slide, it is not changing, sir.
Okay. Now you are not able to see?
No, again, the previous slide is there. That is consolidation and simplification of complex laws. Some you said some fixed.
Yeah, it's not visible. Yeah, 1 minute. Sorry for that. Actually, I spent a lot of time in doing this, unfortunately.
Okay.
Yeah. Now you are able to see this?
Yes, sir.
Fixed term.
Okay, so you start with it. Yes, sir.
Fixed term employment, FTE. You are able to see it?
Okay. Yes, sir.
FTE. So there are some benefits for labor, such as fixed term employment. Okay. So basically, we call the gig workers now. So they can come anytime, go anytime. It's for a fixed term. I'll explain about that. So there is something which has emerged, especially in the categories of employees. There is a new concept introduced: fixed term employment. So it actually benefits both the employer and employee. You can hire and fire. The employer can hire and fire at his will. Similarly, the employee can work for 4 hours, maybe do a lecturing job for 4 hours and do a dance class for 4 hours. Maybe he can pursue his passion. Then moving on to this thing, the other benefits is it reduces the influence of trade unions. We'll see that. It expands the social security net. I'll explain that in my last slide. The social security net for informal sector workers. Okay, I'll explain that. So it's visible, madam, now?
Yes, sir.
So anybody can tell what is the total workforce in our country? Total workforce? What is the total workforce? Both in the organized and unorganized sector. UO is unorganized sector, WF is workforce, MF is not minimum wages, it is migrant workers. What is the total workforce? It is 500.
Around 70 crores. There is an answer, sir.
Yeah, somewhere, 500 million. 500 million is equal to 50 crores. Okay, this is the total workforce. In this, so in this, 90% are in unorganized sector. Please understand this. 90% are in unorganized sector. So 9 into 5, 45. So 45 crores are on the unorganized sector. Okay. Remaining 5 crores. Madam, it is visible, madam, whatever I am writing?
No, sir.
No? Okay.
No.
Okay. Remaining 5 crores is in the organized sector. And if you see the migrant workforce, it is almost 10%, 5 crores. Migrant
Excuse me, sir.
workforce.
If you want, you can use the chat box.
Yeah, sure. Now it is visible.
Yeah, now it's visible.
What I'm trying to say is WFS workforce, we have 500 million. So that is 50 crore out of a population of 130 crore. Okay, UO is unorganized sector. In that 50 crore workforce, 90% are in unorganized sector. So 45 crores are in the unorganized sector. Remaining 5 crore only are in the organized sector, like you and me. Okay. So this MW is migrant workers. This is another, if you see 10%. 10% is the migrant workforce. Why I'm emphasizing on this particular point is, so this new labor code will take care of this informal sector workers. So it will basically expand the social security network. Social security net. Social security is nothing but your insurance, your provident fund, your ESI, bonus, gratuity. Okay, so that is basically the objective. Even for a domestic maid, if you see domestic maid, I'm telling, we are engaging domestic helpers in our society, so in our residence. So if you see, even for the domestic aid, you are supposed to be governed by this new the new labor codes covers them also. So that is what I'm trying to say. Okay, we'll move on to the next one. So we'll see the major changes. It's visible, madam? Major changes?
It's visible, sir. Major
Okay.
changes after that employer has come, sir.
Yeah. Major, what I'm going to discuss now is major changes under the, 1 minute. We are going to see the Industrial Relations Code. Okay, Industrial Relations Code. Under Industrial Relations Code, the Trade Union Act, these three laws have been merged. The Trade Unions Act 1926, Industrial Employment Standing Orders Act 1946, the Industrial Disputes Act 1947. இந்த மூணு கோடும் the Industrial Relations Code கீழே கொண்டாந்துட்டாங்க. Okay, so under the IR code, which we are going to discuss in detail as compared to the other codes, which we are going to discuss in detail, the major changes we are going to discuss in the IR code. What are the major changes? I will highlight. So the definition of employer itself, if you see, has undergone a change. Definition of, as I said, if you see the current definition and the new definition, there is a change. Whatever I have highlighted in maroon font is the change. If you see, employer means a person under the IR code. Employer means a person, okay, who employs, whether directly or through any person, or on his behalf or on behalf of any person, one or more employee or worker in his establishment. So in view of the above change, if you are engaging a contractor, let us say in the current scenario, we are engaging a contractor. Okay, who's the employer? We are engaging a contractor, madam, for a housekeeping work. We are engaging a contract worker for a security guard, for security services, or for canteen management, or for housekeeping. Who's the employer in the current scenario? The employer is the contractor himself. Okay, he is responsible. The liability, even though the liability rests to the principal employer, cannot escape. But as per the definition, the contractor is the employer. But after this change, the principal employer. For example, if you are engaging housekeeping services in your college, you will be engaging housekeeping services. There will be some contractor to do it. That contractor is responsible for those employees. But after this new code is enacted, the college is also responsible for those housekeeping staff. So therefore, the bold whatever I have highlighted is both are responsible under the new code. So contractor alone is not responsible. Principal employer is also responsible if anything happens to the contract workman. So this earlier also it was like that, but it was not very precise. Now they have actually spelled it out in black and white. So the principal employer cannot escape from the liability of the contract workman. So this is a major change. This is a major change which has come. Okay, then the definition of the employer. Moving on to the next. This is what I was discussing. Fixed term employment. Visible, madam?
Yes, sir. Visible, sir.
Fixed term employment. Okay. It means nothing but it's very self-explanatory. Fixed term employment. For a fixed period, you are giving work. You can understand it in that way. For a fixed period, you are engaging a human being. For a fixed period, it is not for that he joins at 18 and he at 18 and retires at 60. It's not like that. So for a fixed term, you are giving employment. So this is something. It's a new concept. There are many advantages of this. As I told, part-time you can do this, part-time you can pursue your passion, and it is also beneficial to the corporate. So in terms of the cost factor, okay, it will not be a big. They can keep their employee costs at control, and they'll have the flexibility to hire on a fixed term basis. But here the beauty is, one should understand the benefits whatever you are giving to a fixed term employee or a worker. Okay, we are having a permanent coach for our cricket team, and we are having a temporary coach. For a permanent coach, you are paying $1 lakh. For a temporary coach, you are supposed to pay the same benefit. You cannot deprive him of the benefit. So that is the beauty of this. So that also they have clearly specified. You cannot discriminate on the basis of the salary, allowances and other benefits, even if you hire on a fixed term employment. The only advantage is you need not be wedded together for lifelong. You can separate any time. That is the only advantage. So it's both. It works both ways. Okay, it works both ways. So even if I want to join some company for a particular project, say, ideal examples for a particular project, they hire me for a particular project and offer me, let us say, for example, I am saying, offer me 5 crores for a particular project. Okay, complete that project. Then I go off. It's that I also know after 2 years, after 3 years, I'll be relieved from the project. I can pursue other activities. So it's something like that. So it was a concept mostly prevalent in the Western culture. Now they have introduced it here. Especially these things, if you see this kind of category of employment is generally, if you see, it's existing among directors. So if you see any director, they hire it for a certain period and then they say, yes, 3 years is your period or something like that. Okay, now they have introduced this for all categories of employment. So even the last point, bullet B is statutory benefits. Point number C is gratuity. Gratuity, the current requirement is, can anyone say current requirement, how many years of service a person has to serve to be eligible for gratuity benefits? Any answers? In order to claim a gratuity benefit from an employer, what is the minimum service requirements? Any answers? So the answer is 5 years. Only if you are in the service for a period of 5 continuous years, you will be eligible for gratuity. Now they have made it as 1 year for fixed term employment. If you take a person for 1 year under FTE, and the contract is for 1 year. After 1 year, you will have to pay the gratuity for that 1 year. So that is the advantage for the employee. Okay.
How much will be the gratuity, sir? What will be the amount of gratuity that we need to pay?
Yeah, there is a formula. The formula is 15 days wages. 15 days wages or salary. It is interchangeably used, these both terminologies. 15 days salary for every completed year of continuous service, which means...
for 1 year means, for example...
Yeah, 15 by 26. That is last drawn basic. Last drawn basic divided by 26.
Yes.
26 into 15 into number of years of service.
Oh, into number of years. So 1 year means 1 year that salary we need to pay.
Yeah, 30 years means 30 years. Okay. There is a cap of 20 lakhs.
Oh,
There's a cap of 20 lakhs. If it exceeds 20 lakhs, it's if you pay 20 lakhs, it's enough. But if you show it in the CTC, you will have to pay the amount above 20 lakhs. Up to 20 lakhs, it is tax free. More than 20 lakhs, it's taxable.
right.
Yeah. So another major changes in the definition of worker. So if you see now, if you see under the ID Act, Industrial Disputes Act, which is my favorite act, Industrial Disputes Act, 1947. If you see, a worker means any person employed in any industry to do any manual means to do any manual, clerical, supervisory, or managerial work is known as a worker, but does not include any person who is employed in a managerial or administrative capacity. In that, there is no change. Okay, it does not include any person who is a managerial or a, but the changes here where it comes is in the supervisory capacity. The current act says employees who are drawing wages up to 10,000 are covered. More than 10,000, they don't come under the ambit of IT Act, under the umbrella of IT Act. But in the new code, they have enhanced this ceiling to 18,000 per month, especially people employed in supervisory capacity. Okay. Workers, yes, everybody are covered under ID Act. Workers, everybody are covered under ID Act. Managers do administrative, managerial or administrative capacity, they are not considered as workers. There is no change. Only persons who are engaged in supervisory capacity, the wage ceiling has increased. So again, one important point is title has nothing to do with the definition. She may be called as a maybe as a manager, but the nature of job is important. She may be doing a job which is basically a job which has to be done by a worker. The designation may be a manager. So there are various things which we don't have time now to discuss. So the last point is, so it includes contract worker also in view of the employer. Okay, they have made it clear now. So contract worker will also come under the definition of worker under the ID Act. So it's very comprehensive. They have made it very comprehensive, very elaborate. So here the important point is which you need to know is earlier wages had a different meaning under different acts. Now in all the four codes, the definition of wages is very simple. I will explain it very simply in simple words. I will explain it. Earlier, if you see, minimum wages will be paid only to those industries which are covered under the Minimum Wages Act, which means under the Minimum Wages Act, there is a schedule. Under that schedule, certain industries are listed, certain industries are not listed. It was applicable only to those industries, that minimum wages. But now what they have done is they have introduced a new concept called national floor level minimum wages. National floor level minimum wages. If the national floor level minimum wages is, say, 750 rupees per day, you cannot pay below 750 rupees per day. So something like that. And the most important changes currently, which is already there, some case laws are going on, especially with respect to PF. Because if you see, under ESA, if you see, you will be taking all the components for ESA coverage, right from your basic to your night shift allowance or conveyance allowance. Whereas under PF, you will be taking only three components: basic salary, dearness allowance, retaining allowance. Retaining allowance, most of the institutions, companies don't have. It's predominantly for industries which are intermittent in nature, like sugar, which operates on seasonal industries. So that is why they need to retain those workers. That is why they have the retaining allowance. So basically, for basic and DA, we are covering the Provident Fund. Now, what they have done is, suppose the basic pay is 1 lakh, to pay PF. 50% of it. 50% should be covered for PF wages. You can have anything. You can have your base. You can have even 25 components: basic wages, conveyance allowance, night shift allowance, washing allowance, special allowance, house rent allowance, pandemic allowance, etc. You can have anything, but 50% should be covered for PF. That is what the new definition says. Any number you can have. If the basic is 50,000, 25,000 should be taken for PF coverage, provided the employer has a policy not to restrict to 15,000. You can restrict it to 15,000, but you should. That's what I'm saying. You should understand the act. Without that, you will not be able to read, because for under PF there is a wage ceiling of 15,000. More than 15,000 is not necessary to cover your employees under PF. Up to, even if the salary is basic salary is 1 crore also, up to 15,000 is enough to be covered. But already, if the company has a practice of paying on the entire portion of basic, then you cannot curtail it. What I'm trying to say is minimum wages cannot be bifurcated further. Whatever name you call X, Y, Z, 50% has to be diverted towards 50% of that amount, and 12% has to be paid towards PF. Okay. So because of this, the next one is, madam, you are able to see, no, madam, layoff compensation.
Yes, sir. Yes, sir.
Layoff means, one should understand, in the Western culture, layoff means termination, completely packing off and sending the person to home. That is layoff in the Western culture. Whereas in India, if you see in the newspapers and all, it is actually misinterpreted. Dash company lays off 3,000 people. You would have read in the newspaper. Dash company lays off 500 workers. Here, layoff means, under the ID Act, it has a different meaning. It is not a permanent separation from employment. Here, it's only a temporary inability of an employer to give employment to a worker. That is the definition. It goes like that: to a worker whose name is born on the muster rolls, for business reasons, due to shortage of coal, power, raw materials, etc. Natural calamity, maybe pandemic may be a reason, but whether it is whether pandemic comes under the business reason, it is a $1 billion question. So similarly, where it's basically the inability of an employer to give employment due to business reasons. Okay, due to business reasons. Financial things cannot be a reason. You can't do that. So, for example, raw material has not come from Gujarat to Chennai for your electronics. Some semiconductors has to come from Gujarat to Chennai. It has not come. So, in a particular section, you cannot give work. That time you can lay off the people for a certain period. Some limitations are there. Okay, Act says for only for a certain period you can lay off, and only for certain people you can lay off. Some rules are there. So what they have done is the layoff compensation has gone up. Why means because this minimum wages has gone up, because it's based on basic pay. Layoff compensation is based on basic pay. So this basic pay itself is going up now. No. Earlier it used to be, for example, I'm saying it used to be 25,000. Because of this elimination of bifurcation, now it will be something like the gross salary will be 1 lakh. This current basic will be 25,000. Under the new code, it will become 50,000. So the layoff compensation will be higher. Whereas retrenchment and closure compensation will remain same, because there is a different formula for it. Retrenchment means only permanent separation under the ID Act. So closure is for financial reasons, basically. You cannot afford to run the business for financial reasons. You permanently close down the undertaking. Okay, again here a major change has come, which we are going to see in the next slide for layoff, retrenchment and closure. I'll just finish this, so it's something relevant to that. See, if you see layoff, retrenchment and closure can be done. Now the current act says if it is less than 100 workers, you need not take permission. That is what the current Industrial Disputes Act says. Under Industrial Disputes Act, okay, it comes under section 25, 25C to 25F. So under that, if you see, less than 100 workers, no need to take permission. Less than 100 employees, no need to take permission to lay off or retrench. Retrench means sending the person home or closure. But whereas in the new code, they have made it as 300. What this means, it gives more power to the employer. That is why trade unions are resisting. Now, if I have 99 employees, I can send them home without taking permission from the government. Okay, varadu varatam apra paathukalam, we can do it. But whereas in the new one, if you see, they have enhanced this to 300. So this is more favorable to the who? Can you tell?
Employer.
Huh?
Employer, sir.
Employer. More favorable to the employer because the limit has increased now. So there is a protest from the unions. At their whims and fancies, you can hire and fire. Employment at will. Cessation at will. Like that. It goes on. So this is one major, very major change. So I have completed that. And moving on to trade unions, just broadly I will tell, we're running out of time. Trade unions, now there is no concept of recognition. Just understand that trade unions have to register themselves. Trade unions have to register themselves. That is different. Registration is there. But in India, the concept of recognition is not there. At least formally. Informally, it is there. If there are three unions, as an employer, we will recognize one union. Informally. Now in writing, you will have to recognize. This is the recognized union. There are 3 unions. Okay. HMS, INTUC, or some other local union. Or AITUC, some union, okay, or a left union or a communist union, some union. So you will have to recognize one union. So that is what they are saying. Broadly, I'm telling. Recognition is mandatory. You will have to only negotiate with the recognized union. Please understand that. You cannot negotiate with the unrecognized union. Negotiate means I'm saying about the collective bargaining in terms of wages and benefits. Okay. So understand that the concept of recognition of trade unions has come in the new code. Then moving on to the next one, again an important change, standing orders. Okay, so the standing orders are basically the guidelines, do's and don'ts for the employees. Okay, it basically consists of the classification of workman, permanent worker, temporary worker, apprentice, fixed term employment, badli, etc. Or your classification will be there. Then your shift hours, rest intervals, uniforms, what are the types of misconduct, what are the do's and don'ts, whether smoking is prohibited at workplace, okay, whether a person has to compulsorily do overtime, whether he can change his shift frequently, all these rules will be there in the standing orders. Okay, the current system is each state has one limit. Tamil Nadu has 100. If you have 100 or more, your standing orders must be certified. Okay, standing orders must be certified. Standing orders are nothing but the rules and regulations governing the conduct of the workman, something like code of conduct. Okay, so 100. So if you say in another state like some other state, some limit in Karnataka or somewhere it is 50. In West Bengal it may be 20. So now what they have done is they have brought in this uniformity of 300 or more. Any industrial establishment having 300 or more workers must have a certified standing orders. Otherwise, the model standing orders it is given in the act that will apply. Okay. And one more new thing is the grievance redressal committee. Earlier, if you see, there were 6 members. Now they have made it as 10. Earlier it was 6. Now it is 10. Similarly, if the worker's grievance is not redressed, within 60 days, he can file an application for the conciliation of such grievance through the trade union to the conciliation officer. So before this was not there. So it was the new thing. Conciliation officer is a third party thing. He will only facilitate the resolving the difference of opinion. He cannot give a decision. He will only facilitate. Both try to mediate and try to reach a settlement. He cannot give a decision. His decisions are not binding. So this is something new which has come. Conciliation officer concept is already there. Referring a grievance to a conciliation is new. Similarly, consultation with the grievance redressal committee in emergency situations for change of shift working. Otherwise, in accordance with the standing orders. Something new, interesting. As I took schedule, shift what are the periods of shift. If during an emergency like pandemic, if you want to change, you can consult the grievance redressal committee. Okay. You want to change the shift. So this we have covered. Enrichment compensation. So here one thing which new has come us in retrenchment compensation is this 15 days average pay is already there. What is new is if you want to rehire a person who has been retrenched, if you are offering employment again to a person who has been retrenched, in such a case, any person within 1 year whom you have retrenched, you have to give preference to that person. So that is a new change. Okay, if I'm retrenching some people today for this thing for any reason, maybe for any reason, downsizing. So within next 365 days, these people have to be given priority over others. This is something. The opportunity shall be given to the retrenched worker who have left within a period of 1 year. So closure, you see I have told 300 workers, major change. Okay. This is something new. The last point. In mining operations, okay. In for example, your aluminum companies or your cement companies will have mines. Okay. If you are providing an alternate because of the exhaustion of minerals in the mines, if you are providing alternate employment at a place located within a radius of 20 kilometers from such undertaking, no closure compensation is required to be paid. I'm closing down the mines because of the exhaustion of minerals. We are digging, there are no minerals. Okay. Maybe in the precious metal industry, you're digging, you can't find gold, and you are not able to give employment, and you're giving alternate employment within a radius of 20 kilometers, then there is no necessity for closure compensation. So this is one thing. So with respect to the other thing,
Time to read the newspaper? Don't worry. Download InShots.
broadly I will cover.
India's #1 English news app provides you all important news summaries of the day, 100%.
Good night, sir. You have to mute.
Yeah.
Somebody has to mute, I think. Yeah.
Yes, I am muted, sir.
Yeah. So code on social security. See, we are going to only touch that. See, code on because there's no time. Code on social security merges 9 acts. I'm just reading out those acts. It's visible, no, madam? Hello?
Yes, sir, visible.
Employee Compensation Act, Employee State Insurance Act, Provident Fund Act, Employment Exchange Act, Maternity Benefit Act, Payment of Gratuity Act, Cine Workers Welfare Fund Act. Okay, if you are engaged in a studio, say if you are engaged in Prasad Studio or Vijaya Studio or an AVM Studio, you will be having these regulations. The Building and Other Construction Workers Cess Act. It's related to the construction industry. The Unorganized Workers Social Security Act, something very important. So these 9 acts have been merged into the Social Security Code. Moving on to occupational safety, health and working conditions. If you see, 13 acts have been merged. The Factories Act, Plantations Act, for tea plantation, coffee plantation, Mines Act, which we discussed, working journalist and other newspaper, working journalist, motor transport workers, BDA and cigar workers, contract labor, sales promotion, interstate migrant workmen.
Sir, merged means...
Merged means all these 13 acts are now independent acts, sir.
Okay. So what I'm asking is, suppose the BD and cigar workers is there. Now it will be coming under a common category, or
it will be coming under the occupational safety, health and working conditions code.
Oh, it's a general code.
Yeah.
But it will be in the separate subsections only, right, sir?
Separate subsections. But what they have done is, for example, let us take a easy one which we all know, Factories Act.
Yeah.
Factories Act has 120 sections, right? Has 120 sections. Similarly, if you see the Contract Labor Act, it has around, I believe, 39 or 37 sections. These two are important acts. So all these both these acts have been brought under the umbrella of occupational safety, health and working conditions. They have just copied and pasted it. That's all. Whatever was there, they have copied and pasted. But having said that, they have done some changes. Some changes have been done, which I have explained with respect to the IR code. Other three codes, in the interest of time, we may not do it. Other three codes also, some major changes are there. So all these have been just.
But the 100 divisions will be there. 100, 120, 50 divisions will be there.
Yeah. For example, in this 13 acts, sir, for example, in the 13 acts, if there are, let us say, 300 sections, Factories Act has got 120, others have got 10, like that. These 300 sections have been migrated to that code.
But same 300 sections are there.
Same 300, but some they have repeated.
Only the heading, and it is coming under occupational safety and measures, right, sir?
Correct. Some they have repealed means they have actually deleted some. They have changed some threshold limits, some definitions they have changed, some threshold limits they have changed. So some changes have happened. The only thing is these things they have brought under one umbrella. Okay, they are brought under one umbrella. So we have 4 broad codes. Which you earlier these were independent acts. Now they are brought under one umbrella. But as you rightly said, all this 300 will go there. There will be some major changes. Rest of the things will remain the same. So out of the 300 sections, if I say some 50 sections would have undergone a change. 250 will remain static.
Suppose if we go to the court of law, I think it will be more easier for people, or what is the objective?
Yeah, code of law. Yeah, the objective is, sir, if you see the definition of.
Tamil, sir.
Huh?
You can tell in Tamil itself. No, sure.
Yes, sir. If you take the definition of wages, let us say, or the definition, we will discuss about Factories Act. The definition of worker. Earlier, it had a different definition. Currently, it has a different definition under Factories Act. It has a different definition under Contract Labor Act. Okay. It may have a different definition under Interstate Migrant Workmen Act. But now what they have done is, they have made it as one single definition. One single definition covering all. So they have simplified it actually. Certain things they have simplified. Certain things it remains same. There are no changes. Got it, sir?
Yes, sir. Thank you.
So moving on to the Code on Wages. This was published in 2019. So if you see here, 4 acts are there. These are separate acts by itself. But if you go under the Code on Wages, you will have these 4 acts. Minimum payment of wages, minimum wages. For example, if you see under the minimum wages, earlier each industry will have a different minimum wage. Auto industry will have a different minimum wage. Automobile industry, as you said, specialty chemicals will have a different minimum wage. The cement industry will have a different minimum wage. Your general engineering industry will have a different minimum wage. Whereas now, what they have done is, it's a common minimum wage. Whether he is a skilled worker in Hyundai, or if he is a skilled worker in Tata Chemicals, he'll have the same minimum wage, provided he is operating in the same geography, the same geography. So they have classified under geographies. Earlier it was state-wise: Tamil Nadu, Karnataka, Kerala, West Bengal, Odisha, etc. Now what they have done is, they have classified under different zones: metro with this much population, tier 2, tier 3. They have classified and they have made a common minimum wages for skilled workers across geographies. Earlier it was industry wise, now it is geography wise. So that is the major difference. For example, a person working in an oil industry in Chennai, unskilled worker and oil worker in oil industry in Chennai, and unskilled worker in specialty chemical in Chennai in same area will get the same wages. Now it is different. Okay, got it, sir? Hello?
Yes, sir. Yes, sir. Yes, sir. Yes, sir.
Now it is different, sir. For example,
Okay.
the oil industry, sir. For example, oil industry, Indian Oil Corporation is having a factory in Chennai. Similarly, Ashok Leyland is having a factory in Chennai. Okay. Unskilled worker at Indian Oil Corporation is getting 500 rupees per day. Ashok Leyland guy, unskilled worker, is getting 400 rupees per day. Now you can't do that in the new code. It should be 500 for both. Irrespective of the
Whatever may be the industry.
whatever may be the industry. But it depends on the city. That is what I'm saying. Chennai will have a higher wage. Bombay will have a much higher wage.
Okay.
Coimbatore will have a lower wage. Pune will have a lower wage.
Based on city compensatory allowance like that.
Yeah, something like that. Based on cost of living, something like that.
Okay, sir.
Okay, so that is what they have done. So these 4 acts are getting merged under Code on Wages. Payment of wages, minimum wages, payment of bonus, Equal Remuneration Act. So these are some of the concerns which I would like to highlight. So it's certain things are against the interests of employees. For example, the layoff part, you can hire and fire at whims and fancies. They have given free hands to the states to frame their own rules. Women's safety now. Now night shift has been allowed in the new code. Okay, night shift has been allowed in the new code. Section 66, subsection 1, subsection C, prohibition of employment of women workers under Factories Act. It's abolished in Tamil Nadu. Tamil Nadu has got a stay. Whereas if you see other states, it's there. Women can work in night shift, especially if you see in the textile industry, etc. But now they have allowed this. So women's safety is a concern. It dilutes the rights of the workers in certain areas. It's somewhat seen as corporate friendly. These are some of the points, some of the points which are against this new labor codes. Maybe criticism against the new labor codes.
Yeah, all these things are points of debate.
Points of debate.
Points of debate.
Yeah. So moving on to the last slide. So what are the benefits? So broadly. So as I said, universalization of the right of minimum wages. Universal minimum wages are applicable and timely payment, including unorganized sector. That only I was emphasizing earlier about unorganized sector. Presently, minimum wages applicable only to 30% of workers. Now you can't do that. Now it covers all the 50 crore workers. Maybe 45, maybe whoever our staff are not covered. All the 49 crore workers it covers. You can't do it only for 30% of the workers. Even in the unorganized sector, it covers. Even a housemaid, I'm saying. Housemaid. Or you are employing a sweeper in your society. Your law, the word in labor law, I'm saying. In any law, the word upon letter. These are some of the benefits.
How do we implement all these things?
You should have compliance. Basically, you should have a person who has good knowledge on labor laws.
No, sir. Now, what I am asking is, we have laws, but nobody follows that. No, for example.
Yeah, they
asking is, we have laws, but nobody follows that. No, for example.
Yeah, they will be inspected. No, sir. If you don't comply, the penalties are very severe. The penalties for non-compliance are very severe. Yeah, very severe. It has gone up from the current thing. It has gone up 5 times. Not only penalty, even the prosecution is there. Penalty and fine and imprisonment, both are there. The main objective is to bring the unorganized sector into all these social security benefits. That is the objective. So appointment letter, annual health checkup, occupational safety and health code also applicable to establishments engaged in work of hazardous nature, even threshold of less than 10. Now it is 10. Even if it is less than 10, this code is applicable. Occupational safety health and code.
Some
Earlier,
issues happens when somebody is working in domestic area. One or two people come. If something happens grave, I think then they will be caught into this law.
Yes. Basically to prevent exploitation, sir. Prevent exploitation. You just engage them till before Diwali. During Diwali, you sack them and don't pay them bonus. It's basically exploitation. Something like that. I mean, I'm just quoting an example. So if you see now, industries with less than 10 or more, this Factories Act is not applicable. Factory means 10 or more with the aid of power, 20 or more without the aid of power, wherein any manufacturing process is carried on. Okay, but now what they have said is this occupational safety and health code is applicable to establishments even with less than 10 workers, where hazardous nature of work is carried on. So some good things are also there. You should appreciate it. So definition of interstate migrant work modified to include migrant workers employed directly. Okay. Earlier, what we said, we engage a person from Orissa or Bihar through a contractor. We call them as interstate migrant worker. We register them with the local police station, produce the Aadhaar card, proof, etc. Now, what they say is, even if we do a direct recruitment from other state, they are also called interstate migrant workmen. Not only through contractor, even if we employ directly, they will also come under the definition of interstate migrant workmen. Then portability of welfare.
Any special thing is there, sir, for interstate migrant workers?
Yes, sir. This is a major advantage, sir. Sir, currently, if you see many industries, if you see, they are engaging migrant.
All textile workers, construction workers, lot of people.
Even engineering, because of the scarcity of manpower, etc. Scarcity of manpower.
What special thing that we have to give them? Anything like that is there, or?
Yeah,
for example,
one thing
worker from Tamil Nadu and worker from Bihar, for example.
You will have to cover them under all the benefits, all the social security benefits. Anything which happens to them, now the contractor is responsible. In the new code, we as the principal employer is responsible. We as all because this pandemic, if you see, people have started walking to their places without transport facilities.
Yes.
You would have seen in the news. Yeah. All these things has been covered here. And moreover, if we are directly employing also, they also come under the interstate migrant workmen. You will have to take now there is a separate license, already a separate registration is there. Now it has been unified into one license. Whatever the benefits you are giving to your regular workers, we are supposed to give them to the interstate migrant workers also. So that is what this new code is trying to bring in.
But implementing this will be a big challenge. It will take a lot of
time.
That
is why it is pending, sir. That is why it is pending. That is why it is pending to roll out. I have made the movie. I am not ready to release it. I made it with 1,000 crore budget. I am not ready to release it. There are no takers for the movie. I have to release it through OTT. So that is the situation now.
Okay.
Yeah. So other major things which I would like to.
Is it practical, sir? Is it possible to implement? Is it possible to implement?
That is the aim of this. That is the aim of this new thing, sir. One way it is. I would say one way it is. It is good actually for both the employer. There are certain benefits for the employer. You can hire and fire at whims and fancies. Similarly, there are certain benefits for the workers also. They are covered under the benefits. It will be a level playing field for all.
Okay, sir.
It will be a level playing field for all. So if you see this gig workers and all, social security scheme, the gig workers like your Swiggy, your Zomato, or for that matter, anybody, one fellow comes through the WhatsApp website. He has everything from A to Z. I'm not able to get the that name. Urban app, urban, formerly Urban Clap, now it is Urban. So there, if you see, these gig workers, Yeah, I had to do a haircutting at my home during the pandemic. So those gig workers should be covered under this social security scheme. All these good things are happening. There is something called a reskilling fund. New thing is introduced. Reskilling fund. If you see this reskilling fund for the people who have been retrenched. So the employer has to contribute something, and he has to reskill the person who has lost his job, so that the new person unlearns and relearns and gets a new job. Okay, all occupations open for women and permitted to work at night with safeguards. This is something something additional security measures we have to provide for the women workers. Provision for social security fund for unorganized workers. So gratuity we have discussed. So these are the major benefits I would say in the new thing. Whether we have time for a quiz or we can drop it, I leave it to you.
Maybe you can give the code, sir. Code, and so that.
Yeah, it will take only.
No, we will do it, sir. We'll do it. Who wants to take the quiz can take it.
Yeah. With this, I conclude my this thing. Maybe finally 1 or 2 questions we can say. We'll do the quiz. It's very interesting actually. We can do the quiz. So 66 participants are still there. So I'm happy about it.
Participation gives us the benefit.
Yeah.
Yeah.
Actually, the actors actually say the real thing is not in the collection of the movie. Only when you clap hands in the movie hall.
Okay.
Similarly, that is the real thing. So all of you can type kahoot.it. Join at kahoot.it. KAHOOT.
Sir, you can display it. You can display the details here.
Yeah, sure.
You can display it. It will be fine.
No, if I display that, you will be knowing that, sir. So you will have to go to a different thing. In your mobile or in your system. Mobile also it's possible. It's only a website, not even an app or website, either ways.
Our students are familiar, sir. It's not a problem.
Okay, kahoot.it. I give you the pin.
Yeah, pin. That is what we want. If you can
827.
No, if you can put it in the slide, it will be good, sir.
Okay.
One slide, one blank slide, if you can put it.
Okay. Sure. Visible, sir?
Sir, you're not present.
Visible?
You need to present it, sir.
1 minute, sir.
You need to present it.
Visible, madam?
No, sir.
You need to come into the presentation screen.
Visible?
Yeah, it's
Now
getting
only,
loaded.
now only.
Yeah, that is the code. 8276463.
1 minute, sir. Still not yet.
Sir, you have come to Google Meet screen. You have to switch the tab to the
Go to the
Kahoot screen.
PPT.
What do you want me to do? 1 minute. Yeah, please.
Go to the Kahoot screen, sir. The tab you have on your screen, right?
Okay.
You're there in the Google Meet. Yeah, this one you have to.
This is what, yeah.
Visible?
Visible, sir.
Yeah, sir,
Visible.
it's visible.
So at least you should have at least 20 participants out of 66. Then we can start. Competition together.
Students like master enter the game pin and log into Kahoot.
Just 10 questions.
All students can enter into.
Only one person has logged in.
8,
Others.
7,
Two.
6, 4, 6.
Got 2. At least we should have 10. Kritika, Femi, then 2 numbers.
Jibin, Jafar, all make it past. Jishna, Joshna.
Sumati, Sherin, Trinad, Joshna, Alex, Sanjana, Nadia, Gomadi. I don't see boys coming in.
Shriren, Mudale, Muthu, all make it past. Surya Prasad, Ashwant.
Julia, Silpa Sasi Kumar, you can start.
Yes, sir. We'll start. Yeah, we'll start.
23 is a good number.
Let them come. Let them come. We'll start, sir.
Yeah. Okay. Surya Danya. Okay. We'll start 25. We have 25. So here we go. The first one. Take it. 4 options are there. There are dash number of legal systems. Okay. 13 of you have got it right. Move on to the next. So who leads the podium? Gomadi leads the podium now. And we have 6036, 6037. I do not know the names. Joshna, Surya. I will see. Okay. Next question. Going on to the next. Dash law is based on legal precedent. 4 options. Religious law, labor law, civil law, common law. Six of you have got it right. Fourth one is the right one. Common law is the correct. Some of you would have got confused with labor law. That is why I put that. Yeah. Right. Next one. Table has tilted. Shilpa Sasikumar tops the chart, followed by Kritika, Anjana, Sherin, and Gomadi. Move on to the next. Dash proposed labor codes merges 13 labor laws. Which code merges 13 labor laws? Thirteen of you have got it right. Again, Shilpa Sasi Kumar is comes first, followed by 6037 Shireen, Surya, and Gomadi. Good, she's maintaining her position at the top. Labor is a matter of dash in Indian Constitution. Very simple, yeah. You should get this right. I want all of you to get it right because it's a very simple one. Great. 19 of you have got it right. The answer is central and state. So move on to the next. Still, she holds the thing. Followed by Surya. We have Surya here, 2642, Gomadi, Diana, and Shireen. Good. That Surya has climbed up to spot number 2. True or false? This is true or false. Under the new Industrial Relations Code, principal employer and contractor will become responsible as an employer. Very simple. We are discussing this in detail. All of you should get it right. "24" have said true, and that is right. Surya has climbed up to the top. I think your market has gone up now. And followed closely by Shilpa, Kritika, Diana, Gomadi. And Kritika has climbed 2 spots. Yeah.
Gomadi is still there fighting it out.
Yeah, fill it out. Moving on to the next. Question number 6. Still 4 questions are there. You can catch up. Come on. Guys who are not in the fray can catch up. The fixed term employment worker shall be responsible for gratuity if he serves for a period of 3 years. True or false? What is this? Yeah, 50-50 like. So 15 of you have said true, 15 of you have said false, and the right answer is false. If he serves for 1 year itself, he is eligible. Why 3 years? 1 year is the answer. What we said, even if he serves for 1 year, we have to give gratuity, we said. Oh, some new entries to the top. Surya, your movie got flopped. Now you have moved on to 5th position, but don't worry, Surya Reporter is there. Again, you can climb there to the number 1 position. Diana is there at 4,014 points. 4,012, just 2 points difference. Followed by Nadia and 6032 and Surya. So still 4 questions are there. If more than one registered union is operative, the union with dash percentage will be the sole negotiating union. Basically a common sense. I didn't touch this. It was there in the slide. If you would have noticed, you would have got that number, but some common sense is required here. It's a wild guess, you can make it. Good, I'm happy. 7 of you have got it right. 51, good. 51 is the right answer. So Kritika, so it's actually like seesaw. It's going like seesaw. So Kritika 4,224 points, Diana 4,014, Gomadi 4,012. 3 of you are above 4,000. Nadia is at 3,849. Femi is at 3,842. Still 3 more to go. Surya can catch up. Standing orders shall apply to industries wherein dash or more employer. Shall apply to industries wherein dash or more employer. In the new code, we are basically speaking about the new code. Only 4 of you have got it right. 300 is the right answer. Now it is 100. It varies from state to state. Tamil Nadu it is 100 now. Earlier it was 20. Then they made it 100. Now also it is 100. New code it is 300. I don't know the name of the gentleman or the lady, whoever it is. 6036 4572. Surya has catched up. Second, Kritika, Diana, and Gomadi. The last two questions, it can be anybody's game. We'll see. Under the new IR code, strike includes. I didn't touch this. Under the new IR code, Industrial Relations Code, strike includes concerted dash leave on a given day by 50% or more workers. I didn't touch this. Actually, there was a slide. Oh, still 5 of you have got it right. The answer is casual leave. So if people take mass casual leave, 50% or more, it means strike under the new code. Earlier, this definition was not there. And going on to the table, Surya has climbed up to number 1. Diana followed by Diana, 6036, Sumati, Kritika. Surya is the rock star. And the last question, how it's going to have change, I really do not know. Let's hope for the best. Still, Diana has a chance. 6036 has a chance. Sumati has also got a chance. Kritika has got a chance. Last question. The new IR code, employer not required to take permission from government for layoff industries employing less than dash number of workers. Easy one. Fairly easy one. Mm-hmm. 6 of you have got it right. We'll see what happens to the standings. Sumati comes third. 6036. And the number 1 is Surya. Just congratulations. And runners up are Diana and Kritika. Surya 6036, Sumati, Diana, and Kritika. Good, congratulations.
6036 is Sridharan, sir.
Sridharan, okay. Good, Sridharan.
Good work by all the members, all the students. It's a great thing. And okay.
Hello. Yes, madam.
Welcome, sir.
Your voice is breaking.
Am I audible now, sir?
Yeah, audible.
You have a question from a participant in the chat, sir.
Okay. What is it, madam? Can you just tell me?
If you can click the chat, you will get it, sir.
Where is it, sir? The chat?
Chat is
Next to people.
Next to?
People.
Okay. Fine. Okay. What is that? Doctors? Yeah, we'll share the part of PPT, not an issue. Then, sir.
You come down, sir. You got to come down, finally.
Yeah. Some Saurabh. I have a question about gratuity amount gained in the professional career. Is it legal for companies to add a gratuity amount in employees' fixed or total CTC while joining? Yes, it is legal. It is legal to add. Okay. It's not illegal. It's legal. It's again benefit. Now PF they are adding. Similarly, PF we are adding. ESA we are adding. Bonus we are adding. Gratuity we can add. Only thing, if you add, you see to it that you are paying the amount above 20 lakhs. If you are not paying that, then that is unfair. You can add. The eligibility to claim gratuity, 5 years, good question, or 4.6 years. It is 5 years. This concept of 240 days, I think you are touching upon the 240 days concept, continuous service, that comes into play only after 5 years. If a person has worked for 5 years and 6 months, then it is considered as 6 years. If a person has worked 4 years and 7 months, 4 years and 11 months, and 29 days also, it is 4 years only. But there are certain case laws. But to be on the safer side, it's better to give the amount. It's a good question, actually. To be on the safer side, it is better to give it. Because after all, he has worked for 4 years. That is what the recommendation as a CHRO I would give. Because he has worked for 4 years and 6 months and 7 months, why do you deprive him of that benefit? But legally, if you ask, there are both. If you put it in the CTC, then you give it. If you don't put it in the CTC, then don't give it. But this concept of this fraction of 6 and above, 0.6 and above, will come only after the completion of 5 years. That is the way we are doing it. But it's a highly debated, deliberated question. Many case laws are there. But to be on the safer side, yes, it's better to pay. At least you can improve your employer brand, and he will be a good brand ambassador for you. He will prefer other employees to join. Any other questions?
And if you have any,
Yes, sir. We will
Sir, hello.
Yes, please.
Hi, sir. Thank you so much for answering me. My name is Saurabh Shinde. I just asked you the question, but I do have a follow-up question for the same as well. I'll tell you a background about myself. I'm a business development professional working for around 4.5 years till now, and I'm in a process of switching my job. And for that, I applied to a particular company, and the company added the gratuity amount in the fixed salary. But I read a lot of answers on Quora and online that is it legal or not. I found it on Quora that many a times that what companies do is add the gratuity amount to your fixed salary, which is never get converted into the salary that we are on a monthly basis that we are getting from the companies. But because it is only after 5 years is what the company has a mandate to give that that gratuity amount to the employees. So that completely becomes a tax rebate for the companies, even though if they are not giving the employees that gratuity amount. So that's why the question arose for me that is it really legal that they can just to make the CTC more attractive, they are just adding the gratuity amount that you will be getting this amount, but you will be getting this amount only after you are there in the company for at least 5 years. So that's why
Sir, I have worked in. I'll tell my experience.
Sure.
Generally, see, I have worked in some companies, corporates. So this is my sixth organization where I'm working. I've worked with big corporates, even like Mahindra, M&M. I've worked with big corporates like V-Guard, M&M, and now it's also a big corporate. Generally, in all the companies, they include gratuity as a part of the CTC. As you rightly said, you had the answer to make it more attractive. But having said that, it is the individual policy of the company to pay the gratuity, whether the employee has served 5 years or not. Typically, what the Payment of Gratuity Act says is 1972. The Payment of Gratuity Act 1972 says is employee, I think it's section 4, employee has to work for continuously 5 years. Then only is eligible for that amount. In your as you rightly said, whether it is right, whether it is or not, that is to be debated. But if you mention it in the CTC as a best practice, it's better to give. If you mention it in the fixed cost and show your CTC as 9.5 lakhs per annum to 10 lakhs per annum, extra 50,000, better to give it off. But if you don't mention it in the CTC, And if you say you will be eligible for all statutory benefits in addition to the above fixed cost, then that is a different ball game altogether.
Okay.
But yes, whatever is the policy the company is following, I worked in one company where I worked for only 2 years. My personal experience I'm sharing. They had paid me gradually. They paid me gradually, even for 2 years. I worked in another company where I worked for the same number of years, whatever you are telling. They didn't pay gradually. So what?
Okay, so it completely depends on the company and the company's personal policy.
Legal standards 5 years is mandatory. But what the new code says is, in case of fixed term employment, in case of permanent employment, it remains same. It's 5 years. But there is a debate going on whether to make it 3 years or not. In case of fixed term employment, if you hire somebody on fixed term employment as a project manager or as a Hadoop thing, if you hire somebody for 2 years, then you will have to pay. Minimum 1 year is enough for fixed term employment. That is a new code. As per the new code on as per the new OSHA's code or code on wages, wherever it is coming.
Okay, sir. And for the follow-up on the second question, would I be eligible after 4.6 years to claim for the gratuity from the companies?
No, you would not be eligible.
Okay.
But what is the company practice? I'm asking. What is the precedence?
The company is basically an online platform.
No, I don't know company name and etc. That you are not supposed to divulge, and we don't want those details. My question is, what is the practice being followed in that particular company for similar kind of employees who have separated?
I'm unaware of that, sir.
That you find out whether they have paid from your finance department. You find out whether they have paid for 4 years, 7 months, 4 years, 8 months, 4 years, 6 months. If they have paid, they will pay to you. If they have not paid, then it's your decision whether to approach the concerned authority or not.
Got it, sir. Got it. Thank you so much, sir, for answering my question.
There are case laws which supports this 4 years, 6 months thing.
Thank you, sir.
Thank you.
Any other questions?
Okay, madam, if that's it, then we can call it a day.
Yes, sir.
Yes. So it's a great session, and again, you've done a great job now, and we hope that we take this forward with some forums, sir. We will work it out at least this year. Last year we could not do it. This year we will try to work on it, sir.
Which is not in our hands.
Yeah, it's true. Thank you, sir. Thank you. Vote of thanks. Vote of thanks is there, sir. Last time. Anybody?
Yes. So, on behalf of Department of Management Sciences, Hindustan College of Engineering and Technology, I express my sincere gratitude to our resource person, Mr. Chidambaram, for sharing your valuable insights, sir. Thanks for sharing your valuable information to our students and making a 2-hour session. It was really useful for our students and all the participants. We had an interaction through quizzes, questions, all. So thanks a lot for being with us and sharing it. I also thank our director, CEO, the management for giving us an opportunity to conduct webinars of this sort. Last but not the least, I also thank all the student participants and participants from other institutions for being here with us for the session. Thank you all.
Thank you.
The feedback form, yes, sir. The feedback form is in the chat link. You can fill it up and get your certificates in a couple of days. Thank you. Thank you, sir. Thank you so much for being with us.
Thank you. Thank you to the institution. Thank you to the HOD. Thank you to the organizer. Thanks to all for having me. I also learned in the process of some valuable questions. Thank you. Thanks a lot. And hope
you're not tired. You're not tired even after 2 hours.
No, that is my passion actually. Teaching is my passion.
That's a great thing.
Yeah. Teaching is my passion actually. I wanted to become a lawyer. I couldn't. Then I wanted to become a professor. I couldn't. I landed up in this, but I'll become a professor.
Yeah.
And 5 years.
You're
Sure.
invited, sir. You're
Thank you, sir.
invited. Yeah.
Yeah.
Thank you, sir.
Thank you.
Thank you, man. Thank you.
Thank you.